Hello, and thank you for tuning in to part two of this training series on DC and perinatal employment leave. I'm Courtney Bernard, and I am an Equal Justice Works Fellow and attorney at the Health Justice Alliance Perinatal Legal Assistance and Wellbeing Project, also known as PLAW. As a reminder, we provide legal advice to your patients for issues that can affect their health. In this video, I am going to focus on medical forms that may come up when your patients are seeking various employment leave benefits during the perinatal period. If you haven't watched part one of this series, which focuses on defining key terms and programs for patients who work in DC, I recommend pausing this video and watching that one first. Otherwise, let's move forward. Health providers play an important role in the employment leave process during the perinatal period. Specifically, for patients to access certain leave programs and protections, they may need health providers to fill out medical forms, and sometimes multiple forms for the same patient. Also, if a new medical condition arises or an unexpected appointment needs to be scheduled, patients may need to have a form updated. This presentation will cover common medical forms associated with DC Paid Family Leave, DC Family Medical Leave Act, or DC-FMLA, and employer-based leave. Let's first start with DC Paid Family Leave. As a reminder, DC Paid Family Leave provides up to 2 weeks of paid prenatal leave and up to 12 weeks of paid parental leave for most patients who work in DC. Patients must apply through the DC Office of Paid Family Leave, and there are standard forms provided on the agency's website that will likely look familiar. Patients will submit separate applications for prenatal leave and parental leave. Prenatal leave requires a medical certification form, but parental leave does not. Here on the screen, you can see the prenatal medical certification form for DC Paid Family Leave. Let's take a closer look. Providers fill out Part 2, including provider information about your patient's pregnancy, the amount of leave needed, and a certification statement and signature. The form is important because the qualifying event for a patient to be able to take paid prenatal leave is when a health provider confirms their pregnancy and or the patient has their first medical prenatal appointment. Patients will be required to include this form when they submit their application for paid prenatal leave. In the amount of leave needed section, select any or all options that apply to your individual patient and list the dates of treatment and or their past or future appointments that you're aware of. Patients can only receive prenatal leave benefits on dates they had a medical appointment or were receiving treatment for their pregnancy and also did not work. That is, if a patient had an appointment in the morning but then went to work in the afternoon, that date would not be eligible for prenatal leave paid benefits. Work with your individual patient to identify the dates that they took or will take prenatal leave. A patient can work with you to update this form and submit it to the Office of Paid Family Leave throughout the prenatal period. I do want to take a brief moment to note that bed rest is listed as an option on the form. The Office of Paid Family Leave recognizes that the term bed rest is no longer commonly used. However, health providers still use this section to describe conditions requiring continuous medical treatment related to a patient's pregnancy that will prevent them from working. You can provide additional information in Part D or attach a brief letter with a description of the required treatment. The Office of Paid Family Leave will generally defer to health providers on this and may follow up with any questions. As a reminder from Part 1, prenatal leave can be taken either intermittently or continuously. Intermittent prenatal leave is most common and is for patients who do not have a medical reason to be off work continuously for up to 2 straight weeks. In this case, you as a health provider will certify the dates the patient has prenatal medical appointments or is receiving treatment for their pregnancy. For patients who do have a medical reason to be off work for up to 2 straight weeks during the prenatal period, you will need to describe the medical treatment or daily appointments that require continuous leave and provide the start and end date. As you saw on the form, providers use the bed rest section to do this. Some of these rules can be complex, and patients sometimes have questions about the legal requirements and process. So, when in doubt, refer your patients out to PLAW. As I mentioned, parental leave through DC paid family leave does not require a separate medical certification form. Instead, after delivering, patients will submit their application with some type of proof of birth, such as hospital discharge papers from delivery or a certificate of live birth. Now let's turn to DCFMLA. As a reminder, DCFMLA is a district law providing up to 16 weeks of unpaid job-protected parental leave after the birth of a child. Unlike DC paid family leave, there are very specific eligibility requirements for this protection based on the number of hours and length of service of employees and their actual employer. So not every patient will qualify for DCFMLA. Patients will apply and receive the required forms for DCFMLA protection through their employer. Although the medical forms for DCFMLA will ask for similar information, they may look a little different and could have specific submission requirements. There isn't one set way that this protection works, so it's important that patients consult their employee handbooks or ask their employers for information about leave policies and the approval process in advance of giving birth. On the screen is a sample FMLA form, and I'll pull up a bigger version for us to take a closer look at. Similar to the DC paid family leave prenatal medical certification, there will be a section for the health provider to fill out your information and then provide information about your patient's medical condition. Unlike the prenatal medical certification form, FMLA forms tend to be very general medical forms and may require more explanation on the part of the provider. There will likely be a pregnancy section where providers indicate the patient's due date. If it applies to your individual patient, there are other sections providers can fill out about other medical conditions related to a patient's pregnancy that prevent the patient from working, which could include pregnancy-related medical treatment. If a patient does have additional medical complications, it is possible they could qualify for up to 16 weeks of medical leave under DCFMLA, in addition to the 16 weeks of unpaid parental leave that the law protects. The FMLA form will ask how much time a patient needs to be off work and/or to receive treatment. The form will ask for a return to work date or an estimated date. When addressing postpartum recovery, even if medically a patient only needs 4 to 8 weeks to recover from birth, and this is what you as the provider puts on the form, legally, patients can receive up to 16 weeks of parental leave under DCFMLA, so long as the patient meets the qualifying criteria. Hypothetically, an employer will only need one form to process 16 weeks of DCFMLA parental leave and any additional medical leave that a patient may qualify for, but we know from experience that some employers can get confused and ask for additional forms, or there could be another issue that requires intervention from PLAW. Finally, we have employer-based leave, which can vary significantly. As discussed in Part 1, employers can supplement or complement DC paid family leave and/or DCFMLA with things like short-term disability or sick leave, which may have their own distinct medical certification forms. There are a lot of nuances based on the individual employer's requirements, but it is worth noting that pregnancy and/or postpartum recovery can qualify as a disability on short-term disability forms when it prevents a patient from working. And I have an example short-term disability form, and we'll pull up a bigger view. So you can see on the example short-term disability form that there is a section similar to the FMLA form where a health provider will provide information about a patient's pregnancy. and any other medical conditions. Again, patients can consult their employee handbook and or their supervisors or HR departments to gather information about what benefits they qualify for and what forms they need to submit. And if you believe your patient is facing a legal issue related to leave, refer your patient to PLAW. We hope this video helped provide some insight into the types of forms you will see from patients who are seeking employment leave benefits and protections. When a patient faces a legal issue related to employment leave, please refer them to PLAW. We are here to help your patients. Please use the QR code on the screen to take the survey to ensure you get credit for watching this video. Note that this is a different survey from the one you took for part 1. Thank you for tuning in.